A woman walked into my branch about 2 weeks after her husband passed. She had a folder under her arm, and her eyes were red, and she set the folder down on my desk and said 5 words I will never forget. I think I owe this. Inside that folder was her husband's last credit card statement, $11,400. And what I told her in the next 10 minutes is what most grieving spouses never get told clearly. So today, I am going to walk you through it the way I walked her through it, calmly, plainly, with the truth. Before I go further, I want to say this clearly. I am not your attorney, your accountant, or your financial advisor. Nothing in this video is legal advice for your specific situation, and the rules change depending on what state you live in and how the accounts were set up. If you are dealing with a loved one's debt right now, please talk to a probate attorney or a free legal aid clinic. What I am sharing comes from 20 years of watching this exact situation play out at the bank. Use it as a starting point. Here is the simplest version of the truth, and I want you to hear it before anything else. When someone dies, their debt does not jump to their family. It does not transfer to a spouse just because they were married. It does not land on the kids. The debt stays attached to the person who died, and it gets paid out of what they left behind. That pile of money and property is called the estate. The estate pays. The family does not. There are exceptions, and I will walk through every one of them. But the default rule is the part nobody hears clearly when they are grieving, so hear it now. The reason this gets confusing is because debt collectors are allowed to call surviving family members. They can mention the debt. They can ask about the estate. And in that moment, when you have just lost someone, it is very easy to assume that if a debt collector is calling you, you must owe the money. You do not. Federal law actually makes it illegal for a debt collector to tell you that you owe a debt that is not yours. But they are allowed to ask if you know who is handling the estate. That is the whole reason they are calling. Knowing the difference is the first thing that protects you. So let me give you the 4 situations where a surviving family member actually does owe the debt. Number 1, you co-signed the credit card application. Number 2, you were a joint account holder, meaning your name is on the account as a primary owner. Number 3, you live in a community property state and the debt was incurred during the marriage. Number 4, your state has a necessary statute that obligates spouses to pay certain debts like medical bills. If none of those 4 apply to you, the credit card debt is not yours. It belongs to the estate. Now here is the part everybody misses. Being an authorized user on a credit card is not the same as being a joint account holder. An authorized user is somebody who got handed a card with their name printed on it, but they never signed the original application. They were added later. The Consumer Financial Protection Bureau is very clear on this. Authorized users are not legally responsible for the balance when the primary cardholder dies. So if you are a spouse who has been swiping a card with your name on it for 10 years and you never signed for the account, you do not owe that balance. The estate does. Community property states are the one place this gets genuinely messier. Those states are Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin, plus Alaska if a special agreement was signed. In those states, debts taken on during the marriage can be considered shared, even if the surviving spouse never signed the credit card application. That does not automatically mean the surviving spouse pays out of pocket, but it does mean the estate analysis gets more complicated. If you live in one of those states, this is the moment you call a probate attorney. Not next week, this week. Here is what actually happens at the bank when a death certificate hits the system. And this is the part nobody outside banking knows. The credit card account does not auto-close. The bank does not get notified by some magic government feed. Somebody, usually the spouse or the executor, has to call the issuer and report the death. When that call comes in, the account gets flagged. New charges are blocked. Interest sometimes keeps running, sometimes stops, depending on the issuer and the balance. And the balance gets handed off to the estate department for collection through probate. That is the actual mechanic. The next question I always got was, do I have to pay this out of my own savings? And the answer is almost always no. The estate pays first, from whatever the deceased left behind: cash, the house, retirement accounts, brokerage accounts, vehicles. If there is enough in the estate to cover the credit card balance, the credit card gets paid. If there is not enough, then state law has a priority order. Funeral costs and family allowances get paid first, then secured debts like the mortgage, then unsecured debts like credit cards. If the estate runs out of money before the credit cards get paid, those unpaid balances are written off. The family does not owe them. Most states give the surviving spouse what is called a family allowance. That is a chunk of money set aside for the spouse to live on during probate, and it is paid before the credit card company gets a single dollar. State amounts vary widely. In Colorado for 2026, the family allowance is $44,000, with a separate exempt property allowance of another $44,000. So $88,000 in protected assets before the credit cards see anything. Other states are smaller. The principle is the same: survivors come first. Now, what happens if there is no estate at all? The deceased had no house, no savings, no investments, just a credit card balance and maybe some clothes and a car worth less than what they owed on it. In that situation, the credit card debt typically goes unpaid and gets written off as a loss. The credit card company eats it. The family does not pay it. That is exactly how the system is designed to work. Unsecured creditors take the risk that the person they lent to might not be able to pay. When the borrower dies and the estate is empty, that risk gets realized. End of story. One thing the credit card company can never do is force the family to liquidate assets that were not in the estate to begin with. Life insurance proceeds paid directly to a named beneficiary do not go through probate. Retirement accounts with named beneficiaries do not go through probate. Jointly owned property that passes by right of survivorship does not go through probate. All of those assets transfer directly to the survivor, and the credit card company cannot touch them. This is one of the most powerful reasons to keep beneficiary designations updated on every account. It is the closest thing to a credit card shield that families have. So back to the woman at my desk with the $11,400 statement. I asked her 3 questions. Did you co-sign the original application? No. Was your name listed as a joint account holder, not just an authorized user? No. Do you live in a community property state? No. This is Minnesota. So I told her, plainly, you do not owe this. Her shoulders dropped about 3 inches. She had been carrying that folder around for 2 weeks, convinced she was going to lose her house over a debt that was never hers to begin with. And the only thing standing between her and that relief was somebody willing to explain it. Here is what I told her to do next, and what I would tell anybody in the same spot. Step 1. Order at least 10 certified copies of the death certificate. You will need them. Step 2. Notify the credit card issuer in writing with a copy of the death certificate that the cardholder has passed and that you are not a joint account holder. Step 3. Ask for written confirmation that the account is closed. Step 4. Notify all 3 credit bureaus, Equifax, Experian, and TransUnion, so a deceased flag goes on the credit file. Step 5. If a debt collector pressures you, hang up and consult an attorney. One last thing about debt collectors, because they are the source of most of the fear in this whole situation. Under the Fair Debt Collection Practices Act, a collector cannot lie about who owes the debt. They cannot threaten you with a lawsuit they have no right to file. They cannot harass you, call you at unreasonable hours, or contact your employer about a deceased relative's debt. If they do any of that, write down the date and time, get the company name, and report them to the Consumer Financial Protection Bureau and your state attorney general. That paper trail is the single fastest way to make the calls stop. If you are watching this video right now because you just lost someone and the bills are starting to arrive, I want you to take a breath. The grief is real. The paperwork is real. But the panic about being personally on the hook for tens of thousands of dollars in credit card debt, that is usually not real. The system is built so that the estate handles the debt. And if there is no estate, the debt is the bank's problem, not yours. Get organized. Get a probate attorney if the estate is anything more than simple. And give yourself permission to grieve without carrying somebody else's bill on your shoulders. If you found this helpful, the kindest thing you can do is share it with somebody else who is going through this right now. Most grieving families never get this explained clearly, and a video like this can save them weeks of stress. If you want a step-by-step plan for building credit from the ground up, I made a video called How to Build Credit from Zero, the 12-month plan a banker would use. Watch that one next. And if you want more banker insider answers like this one, consider subscribing.